Justice under siege, DSS bars, access to vital files, threatening Nnamdi Kanu's self-defense tomorrow. As the sun rises over the Federal High Court in Abuja tomorrow, the long-shadowed trial of Mazi Nnamdi Kanu, the detained leader of the indigenous people of Biafra, IPOB, enters a pivotal phase. Scheduled for November 4th, 5, and 6, the proceedings before Justice James Omotosho mark a potential turning point. The adoption of final written addresses on Kanu's bold no-case submission or the forced opening of his defense. Yet this high-stakes hearing is already mired in controversy, with fresh allegations of Department of State Services DSS obstruction that could undermine the very foundations of due process. At the center of the storm is today's alarming incident involving Kanu's brother, Prince Nnamdi Kanu, who was reportedly detained and blocked from securing vital documents for Kanu, raising urgent questions about fair trial rights and the integrity of Nigeria's justice system. Kanu's legal odyssey, spanning nearly a decade, has been anything but ordinary. Arrested in 2015 on charges of treasonable felony, he was granted bail in 2017 by Justice Binta Nyako on health grounds, only to flee following a deadly military raid on his Abia state home. His rendition in 2021 from Kenya, deemed unlawful by courts in both nations, thrust him back into DSS custody, where he has languished ever since, facing 7 counts of terrorism, managing an unlawful society, and incitement under the Terrorism Prevention Prescription Order. The prosecution, led by Chief Adegboyega Awomolo Esan, rested its case in June 2025 after parading 5 witnesses, including DSS operatives who tendered evidence like Kanu's personal effects and Radio Biafra equipment. But cracks emerged early. Justice Omotosho struck out coerced statements and videos in May 2025, citing duress during a trial within a trial. Kanu, now self-representing after sacking his star-studded team, including Chief Kanu Agabi, San, on October 23rd, has repeatedly decried the charges as baseless. On October 27th, Kanu withdrew plans to call 23 witnesses, including foreign ones and family members like Emmanuel, and filed a no-case submission, arguing the prosecution failed to establish a prima facie case. He followed this on October 30th with a fresh motion demanding all charges be struck out, claiming they rely on repealed laws violating Section 3612 of the 1999 Constitution and extraterritorial acts in Kenya unvalidated under the Terrorism Prevention and Prohibition Act, TPPA, 2022. Tomorrow's hearing could deliver that verdict, potentially freeing Kanu or compelling his defense, amid health pleas, a September 2025 bid for hospital transfer, and international scrutiny from Amnesty International, which has slammed the process as a farce. Compounding the tension, yesterday's events at the Supreme Court premises in Abuja exposed the trial's fragility. Prince Nnamdi Kanu, Nnamdi's younger brother, arrived to process vital legal documents, likely affidavits, medical reports from a September 23rd Nigeria Medical Association exam, or witness statements essential for the defense. Instead, DSS operatives allegedly barred entry, detained him on site, and threatened arrest, as detailed in a viral post by Emmanuel's wife, Favor Michael Kanu. DSS reportedly blocks Prince Kanu from entering into the Supreme Court. One of them is threatening to jail Prince Kanu. Forced a swift release hours later, with Favor crediting the power of social media. But the damage lingers. This isn't isolated. DSS has a documented history of denying lawyer visits. Examples: October 31, 2025, despite court orders. Seizing documents and eavesdropping, violating twice-weekly access mandates. In April 2024, Kanu's team decried photocopied and unreturned files, crippling preparations. For tomorrow's hearing, the implications are stark. Without these documents, Kanu, already self-representing and health-compromised, may struggle to substantiate his no-case arguments or mount a defense, echoing October 24's adjournment over a withheld case file. Rights groups decry it as state harassment, potentially dooming witness testimonies like Emmanuel's. DSS interference isn't mere bureaucracy, it's a legal landmine. Under Section 36(6)(c) of the Constitution, Kanu enjoys an unqualified right to defend himself in person or by legal practitioners of his choice, with unfettered access to counsel and documents. Blocking Emmanuel, a key witness, flouts this alongside UN Basic Principles on the Role of Lawyers and the African Charter on Human and People's Rights, ratified by Nigeria. If documents remain inaccessible, Justice Omotosho could view it as prejudice, bolstering Kanu's motion. Precedents like Ioko v. Fagbemi, 1961, void proceedings on non-existent laws. Here, obstructed evidence could render the trial manifestly unfair, per Section 36(4). A no-case win might follow, or an appeal citing abuse of process. DSS defiance invites contempt charges against its Director General, as in a 2024 federal High Court notice. Petitions like Dr. Seprabofa's October 20, 2025, filing to the Chief Judge demand probes into demeaning blocks, potentially halting other court functions. As Kanu enters court tomorrow, flanked by observers but starved of full resources, the world watches. Will Justice Omotosho rule on the motion, quashing charges and ordering release? Or will interference force yet another adjournment, perpetuating what critics call a trial by ordeal? This isn't just Kanu's fight, it's a litmus test for Nigeria's rule of law. In a nation weary of impunity, the echoes of today's blockade could reverberate far beyond Abuja's courtrooms, demanding accountability from the DSS and beyond. For now, one truth endures: justice delayed is justice denied, but justice obstructed is justice extinguished.